Hello, happy hump day. It's Wednesday. Hump day, hump day, hump day. Welcome back to my channel. Sadly, that's the only celebration of the hump day I will be having today. But welcome back. There is a lot to get into. We are going to get into all the new motions filed from where we left off from Friday's big day of motions. Everything It Ends With Us. You get it right here. And yesterday, the 12th and the 13th was big days. Brian Freeman clapped back. Stephanie Jones is fighting for her life. I mean, dang, she's trying everything to get rid of this sham subpoena. She is fighting, girl. She is fighting. And then we're going to go over a few of your comments that I found were pretty interesting and made me think a lot. And yeah, first we'll just get into some fast news, and then we'll get into all of the motions from where we left off in the last video. If you haven't seen that and you want to stay up to date with all of the court filings in It Ends With Us, I'll link the video below. But yeah, if you're ready, I'm ready. Grab your emotional lip gloss because we are diving right in, right away. Let's get into it. You're in frame with Mandy Magnan. Yesterday we talked about Ryan Reynolds appearing on the Conan O'Brien show and how many comments were definitely letting him know that this was completely unacceptable. Well, right below that and on the same day, you have Ryan Reynolds doing the late night talk show with Stephen Colbert. What is going on? And this was all about Wrexham and his new projects. And I truly believe that under this video, they are deleting or removing comments or heavily filtering them because none of them have to do with It Ends With Us. And that's just a little bit strange, right? That none of the comments, they were all pro Wrexham, pro Ryan Reynolds. None of them had anything to do with It Ends With Us. Really, because if you look at the video of the Conan O'Brien, as well as when Blake showed up on the Seth Meyers show, the world is kind of echoing exactly what we think of this situation. So to have not even one comment under these videos be about that situation, to me just screams that they are like filtering or removing comments, but that's just my opinion, of course. But how absolutely tasteless. Like, Ryan Reynolds, go away. It's so bizarre. To me, it's just so weird and bizarre. It screams narcissist. It screams, hey, I know what I'm going through, but you can't touch me. You can't touch me. I am powerful. I am Khaleesi. Because how does one person show up on everything, his face literally plastered everywhere now, more than ever, when he has so many allegations against him and is fighting one of the biggest lawsuits? He's also being dragged in the courts by Brian Freeman, which we will get into momentarily. And all of this is going on. The whole world, not the whole world, but a majority of people have woken up to you and your wife's tactics and the abuse and the complete sheer takeover you did not only on this film, but other projects as well. You have all of this coming down on you, and you're on talk shows just being like, Gucci, everything's fine, everything's normal. It's weird, bro. It is weird. It's so unhinged. Like, it just screams to me like narcissist at its max, because how are you acting like this when all of this stuff is going on? It's weird. It's weird. It's weird. And frankly, I think a lot of people are sick of it and they can see right through it. And it's just like, maybe you should deal with your own stuff that's going on. Take a break, deal with your stuff, and then come back. But to continually like just push yourself in front of our faces at every single chance, more than ever, to me screams, I know what you guys think. I know what I've done. And you can't do anything about it. I am untouchable. I am Khaleesi. To me, anyway. That's what, like, I just think it's just so, like, gross. He did say, wow, what was that? He did say something very interesting. I haven't watched the entire interviews, nor do I want to, because I do not want to support anything RR. But I did find little snippets of things that he said, and he did say something like, and I will quote, because this is the quote here. He said, "It's the ecstasy and joy that you can't believe exists in this world right now that we live in. We live in a digital hate tank. Is it a digital hate tank, or is it you're corrupt, you did unlawful things, you're immoral, you are super shady, you're powerful that likes to step on little guys, and your tricks and your antics and everything that you've been doing for the last decade are now coming to light, including allegedly buying the plantation that you got married at? Yeah. So is it just a hate tank, or is it actual people holding you and your wife accountable for doing absolute evil things to people who are just trying to live their dreams, and you guys come along and just snatch it from them? I would consider it more of that, being held accountable, than I would being a hate tank. Although, yeah, I do agree, sometimes the internet is very awful. I get a lot of mean comments and people drop little things in my inbox, but I don't consider it a hate tank. I think this is a great community where people can, especially on this channel, expose what is going on in the dark and bring everything to light. Still, a lot of the headlines today are how Taylor Swift was subpoenaed. She wasn't subpoenaed necessarily. It was now her law firm was subpoenaed for communications. This tells me maybe that Brian Freeman has some things up his sleeve that we still don't know about. I'm pretty sure there's going to be some things going on with Ryan Reynolds and Blake Lively for filing this fake lawsuit in order to get the sham subpoena. And again, it just makes me really wonder Taylor Swift and Blake Lively's entire friendship. Because if it was me, right, and I was being repeatedly sexually harassed on set, you're calling your bestie, you're talking to your bestie, you're texting your bestie, right? And I mean, and in Blake's own lawsuit and her amended complaint, she says how she was texting other females, other co-stars, number one, as well as a friend of hers and Justin's, and was complaining to them about it, how she's dreading going back on set, how they're creeps, how there's clowns, etc., etc., etc. So why wouldn't she be texting her best friend this? Now, as her best friend, Ms. Taylor Swift, if that was me and I was being, subpoenaed for my communications, I would be like, here you go. Here's everything. Here's every text message that my best friend sent me about Justin's behavior. Here's every text message that she sent me, how disturbed she was about the birthing scene and how she was crying to me after it happened. Here's the text messages when she was going through a depression and not able to leave her house because of the smear campaign. Here it is. And I want this monster to go down. So yes, Justin was doing this to my best friend. Here's the proof. Do you know what I mean? I would go to war with the truth and God behind me if this was happening to my best friend. I would show everything. Which this tells me that, number one, Blake is lying. Don't like to say it, but why not show the truth? Or number two, Taylor does have a bigger part in this whole film takeover than she's willing to admit. But something weird is going on, or maybe they're not even best friends. It seems like Taylor Swift is a lot more close to Ryan Reynolds than she is to Blake Lively, even though they do these event pictures together, Super Bowl pictures and what have you. Because Taylor, she reposted some of the Deadpool and Wolverine stuff. She's reposted things with Ryan Reynolds. She, from what I know, prove me wrong, from what I'm aware of, Taylor Swift never reposted anything about It Ends With Us or Blake Lively. And I remember seeing an interview on the red carpet with Blake Lively, and if someone can find this little clip, I couldn't find it this morning, but it came to my head when I was thinking about this, that there is a clip where when Taylor Swift was on tour, something happened with the arena she was supposed to perform. There was a threat or whatever, and a threat like that. It was evacuated or something. I remember that. And Blake Lively was asked about it on the red carpet, and the way she dismisses the question and moves on completely, to me, maybe Blake was really good at using Taylor Swift as leverage, but didn't ever want Taylor Swift to overshadow her on this film. And that to me screams, again, a little bit of jealousy in your friendship or anything like that. So I don't really know what's going on, but it is baffling. It is really like on my mind, like, why wouldn't Taylor, if this was her best friend or even her friend, why not just show the messages? Why not just be like, here is every time she texted me about this creep, Justin Baldoni, and I want him to pay because this happened to my friend. Here you go. Dun, 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 dun. Which tells me if they're fighting so hard to not show that, then one, it either didn't happen, or two, there's a lot more going on under the surface that we know about right now. But I think Brian Freeman is definitely onto something, and I think some things are about to go down. Like, serious. We left off on Monday with all of the motions and letters filed in the court on Friday. Friday was a pretty big day. Everyone kind of got their lick back, you know. And then on Monday, we went over all of that. We kind of left where they've brought up now the fake lawsuit and the sham subpoena with Stephanie Jones saying it's fraud, it's crime, and that's why they should be able to get the text messages that from Stephanie Jones's Edgeworth security company. She's claiming there's a privilege there, a client confidentiality privilege. Wayfair has now introduced the crime fraud, and now we are here. So there are a lot of things, as you can see, that have been filed in the last 2 days. A lot of them are pretty quick, so we're just going to go over the whole rundown. And yeah, buckle in, but if you're down to read the court dockets with me, I am going to present them here and everything that I found kind of relevant, and it will keep us up to date on what is happening thus far. So the judge had already kind of made a ruling when it comes to communications and pretty much tried to stop how many letters and submissions and motions were to be filed. So you can submit like one letter in response. So it's not like so much joggle going on. So when the Wayfarers responded to Stephanie Jones inciting the crime fraud and etc., Stephanie Jones she put in a request to be granted a letter of motion. So she filed a motion in order to be able to submit a letter in response. And the judge was judging because he was like, all right, cool. I'll grant you this, but you have until end of day. You have until tonight, May 12th, to submit that letter. And that's what we're going to start with. Stephanie Jones's letter filed on May 12th that was granted by Judge Lehman. And when I tell you things get juicy and spicy by the end, because Brian Freeman is not playing anymore with these people. All of their publicity tactics, all of the letters that they're filing, which is nonsense and just wasting, number one, the court's time, and two, just trying to get headlines so that they don't have to deal with what is really going on. It gets juicy and he addresses all of it. But before then, we have Stephanie Jones with the gaslighting in 3, 2, 1. Because OMG, this woman, she is just battling. And this is just in this case. There's also the case that involves her where it's just Wayfair and Jennifer Abel, two of those against Stephanie Jones, vice versa. So this is Stephanie Jones's letter that she was able to get filed yesterday. And we'll just read it quickly here. Actually, we're just going to backtrack. So this is the letter that she filed in order to file a letter. Okay, if that makes sense. So she asked the court on May 12th, she submitted this letter for leave to file a letter to reply addressed by what had just happened. The judge granted a letter for motion for leave to file the document, but he also said the reply shall be filed no later than May 12th and no further submissions on this motion. So this is the letter that she filed in order to get that letter granted, but I think it is worth reading anyway. Sorry, I did that a little backwards, guys. I was jumping right in, okay? I got way ahead of myself. So this is the letter of, Stephanie Jones, but it is worth reading because what she says here is quite interesting, I suppose. Pursuant to Rule 4C on this court's individual practices, Jones Works LLC respectfully requests leave of this court to file a letter no more than 3 pages in reply to Wayfarer Party's opposition to Jones Works' motion for a protective order. A mere 2 hours after Jones Works filed its letter motion for a protective order to prohibit enforcement of a subpoena served on a third party, Edgeworth Security Services LLC, that plainly seeks from Jones Works' privileged documents, the Wayfarer parties filed a 3-page letter motion seeking to invoke the crime fraud exception to overcome that privilege. During multiple conferrals over the course of more than a month, the Wayfarer parties did not once mention the crime fraud exception as a possible basis for overcoming Jones Works' well-founded assertion of privilege. This is for good reason. The exception is wholly inapt. The Wayfarer parties flouting the court's conferral requirements and hiding that their intent reveal that the pre-baked opposition to Jones Works' motion is without merit or good faith basis, and instead appears primarily designed to further their outlandish media narrative against Jones Works. Further, because the Wayfarer parties concealed their intent to raise the crime fraud exception in relation to the subpoena and failed to raise it on any conferral, Jones Works, of course, has had no opportunity to address the issue and its inapplicability to the present situation. This type of sandbagging and litigation by ambush is precisely the type of conduct that this court has recognized warrants permitting a reply. Okay, Stephanie Jones, did you not give all of the communications between your client, Wayfarer, Justin Baldoni, your ex-staff, Jennifer Abel, through a fake lawsuit with a sham subpoena? Do you think they knew anything about that until it was discovered by Without a Crystal Ball here on YouTube? No. And you're here, oh, well, they didn't tell me anything for the past month. I had no idea they were going to bring it in. As if. This is why you brought on, Stephanie Jones brought on many other lawyers that deal with crime, would deal with defense, that deal with all of this stuff. So it's like, cry me a freaking river here. Honestly, like, that's what I think about Stephanie motherfucking Jones, okay? Then in the footnote, I found it very interesting. It says, the timing of the filing alone reveals that the Wayfarer parties have been lying in wait to file this motion, as does the reference in their letter to false imprisonment, which one of its 6 claims Jennifer Abel abandoned in her most recent abandoned counterclaims in the related case and is at the time no longer pursuing. Jones Works' expected reply will include argument that 1. The facts stated in the Wayfarer party's response are flatly false, and they and their counsel know they were false when asserting them to this court. 2. The Wayfarer party's invocation of the crime fraud exception is patently frivolous, including because they failed to present even 1 iota of evidence to substantiate their false assertions, despite acknowledging that they must do just that to support application of the exception. And 3, the Wayfarer parties are abusing the court's docket for extrajudicial purposes, including to launder defamatory statements about Jones Works through documents ostensibly protected by the litigation privileges. Jones Works thus respectfully requests that the court grant it leave to file a letter reply to assist in the court's resolution of the instant motion. Oh boy. So then, yes, once again, after the judge read that, he was like, you know what, file your letter, but this is the only one and it needs to be done by end of day. The next thing to be filed in the court was a letter response in opposition to motion addressed to the judge. This was filed from the Wayfarer people, and this is a letter motion to compel the Wayfarer Studios, and this is in response. So it's a letter response, but this was filed from the Wayfarer party. So let's talk about it. They say, dear Judge Lehman, I don't know. Let me know which one it is, because I've seen people say it so many different times, but the judge, anyway. Dear Judge Lyman, as counts for Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, Steve Soritz, It Ends With Us, Movie, LLC, Melissa Nathan, The Agency, PR, LLC, and Jennifer Abel, collectively, the Wayfarer parties. we write in opposition to the motion by Blake Lively to compel certain discovery from the Wayfarer parties. In contract... Oh, you already know they're going to go in. So this is a letter in response to Blake Lively saying, the judge needs to step in and compel the Wayfarer parties because they haven't submitted anything to us. They haven't submitted any of the things we've asked for. It's in the last video, but this is their reply. In contradictory statements, Lively simultaneously A, acknowledges that the Wayfarer parties have confirmed that they will produce non-privileged documents concerning their damages, and B, incorrectly argues that the Wayfarer parties have refused to produce specific financial records relevant to their damages. Given that there is no need for judicial intervention at this juncture, it appears that Lively's true purpose in filing the motion was not to compel discovery, but to fabricate a headline for the media, regardless of whether the motion wastes judicial resources or not. And for a good measure, it is worth noting that Lively herself has not produced a single document or explained how she searched for and collected the documents that her counsel claims to have gathered from her but not produced to us. During the parties' telephonic meet and confer, the Wayfarer parties assured Lively that they were in the process of gathering documents responsive to her request, and specifically that the Wayfarer parties would produce non-privileged documents concerning their respective damages. Contrary to Lively's ongoing mischaracterization to the court, the Wayfarer parties did not refuse to produce the requested documents bearing on that loss. Furthermore, the Wayfarer parties suggested that if upon receiving the damage-related documents the Wayfarer parties produced, Lively believed that additional documents should be produced, then she should notify the Wayfarer parties of that position and not... I'm so sorry, guys. My eyes are getting like... Whew, that was weird. I think maybe that was the mascara. Well, it's a good time to take a lip gloss break. Maybe that's the problem. My lips are popping. You need the gloss. Okay. Sorry, but twice there my eyes were like, whoa, what's going on? What is this? Okay, let's just go back. Furthermore, the Wayfarer parties suggested that if upon receiving the damage-related documents the Wayfarer parties produced, Lively believed that additional documents should be produced, then she should notify the Wayfarer parties of that position, and the parties would meet and confer in good faith in connection therewith. Lively agreed that that was an acceptable manner of proceeding. Tellingly, even after changing course in her subsequent email correspondence, Lively has not explained why such procedure is insufficient, especially given the number of dismissal motions and discovery motions already on the court's docket herein. Lively's request for production, RFP, to BALDONI, which is the same as her different numbered request to other Wayfarer parties, seeks documents sufficient to show your net worth, including financial statements, assets, liabilities, and tax returns. The Wayfarer parties have already agreed to produce documents concerning their damages, which documents may include, for instance, financial statements reflecting a reduction of business revenue. However, the motion fails to explain why the net worth of each of the Wayfarer parties is relevant to any party's claim or defense and proportional to the needs of the case. Denying application for disclosure of defendant's assets because plaintiffs made no showing that defendant's current financial condition of net worth bears any relation to their application for relief. Due to the private nature of the sensitive information contained herein, and in part from the public interest in encouraging the filing by taxpayers of complete and accurate return, courts have long been reluctant to order discovery of tax returns. Then they state some laws where that is the case. Lively has not shown that the Wayfarer parties' tax returns are relevant to the subject matter of this action, and hence her request for such sensitive information should be denied. Moreover, when Lively identifies the relevant information from the tax returns that she purportedly needs, we are confident that any such information will be readily available from a less intrusive source. None of the cases cited by Lively warrant compelling the production of tax returns herein. The phrase tax returns is not mentioned in one source ever on, and hence it is unclear why Lively cited to that case. So they're saying even the cases that Lively cited herself in order to get these documents doesn't make sense. Yet again, calling her out. This has happened many times where they cite all of these things and then the Wayfarer people come back and they're like, what you're citing doesn't even help your case, you know? The court directed the plaintiff to produce his tax returns after he failed to produce other documents, such as financial statements concerning his alleged damages. Here, to the contrary, the Wayfarer parties will be producing documents concerning their damages, obviating the need for tax returns. That case involved a post-judgment subpoena for tax returns, and the court held that the judgment debtors' tax returns are clearly relevant to defendants' enforcement of their judgment, especially because the judgment debtor has been less than cooperative in producing any of the documents requested by defendants, thereby creating a compelling need for tax returns. No judgment has been entered herein, much less in Lively's favor. In the motion, Lively also refers in passing to her RFP seeking all documents concerning your liquidation of assets in 2024 or 2025 for any reason related to the film or the actions, including but not limited to the sale of shares any publicly traded company. Nowhere in her 3-page letter does Lively even attempt to explain, let alone sufficiently explain, how any such responsive documents are relevant to any party's claim or defense. Furthermore, during the parties' telephonic meet and confer, Lively did not provide any basis for seeking documents concerning the liquidation of assets by any of the Wayfarer parties. Indeed, even in her self-serving and lengthy summary and memorialization, oh my gosh, she's so funny. Indeed, even in her self-serving and lengthy summary and memorialization of the parties meet and confer, Lively does not explain why documents concerning any liquidation of assets is relevant to any claim or defense herein. Denying requests for reconsideration of motions to compel where Movent did not explain how discovery sought was relevant. In sum, Lively failed to meet and confer about her request for documents concerning the liquidation of assets in violation of Rule 4C of Your Honor's individual practices, and then omitted from her motion any justification for the production such documents. We respectfully request that the court denies Lively's motion. Basically, in this letter of reply, what the Wayfarer parties and Brian Freeman are saying is that first, Blake Lively hasn't even said why she needs these. It's kind of a fishing expedition yet again. She's fishing for irrelevant financial details, and also that she herself has broken the violation of Rule 4C, which is this judge's honors individual practices, and this judge specifically has rules that he wants to follow, and 4C is one of those where the parties must try to resolve the discovery disputes themselves before going to the judge, and Blake Lively never did that, and she's never explained why she needed these. Like, why? Not ever once did she explain in her court filings why she needs the liquidation of assets or tax returns. It's very strange, but yeah, okay. Again, I truly believe that this was just, they're just trying to get headlines, trying to block the SEO, trying to change the SEO to always have negative attention onto Justin Baldoni, that he's not complying, he's not answering, he's not going to prove how he's owed $400 million, etc., etc., etc. The next thing filed on May 12th was a proposed stipulation and order document, and this was filed by Blake Lively, and Ryan Reynolds. It is quite a long document, but we are going to read a few things. It's kind of like just an agreement of how they're going to share things, when they're, it's really like working with kindergarten or with kids, you know, like these are the rules, these are the stipulations that we're going to follow, and they put this into the court. And yeah, there's just a few things that we can go over on here. We're not going to go through all of this stuff because then there are things that say like, okay, if we're using this word, it means give us all of this. This means this, you know, when they're searching for documents and how they're going to do it. But this is a joint stipulation on the protocol for discovery of electronic stored information and hard copy documents. It says, hereby stipulate to the following protocol for discovery of electronically stored information, documents, and hard copy documents, ESI protocol, or stipulation in the above captioned consolidated cases, cooperation. Number 1, the parties commit to cooperate in good faith to effectuate the provisions of this stipulation. Number 2, the stipulation shall not enlarge or affect the proper scope of discovery in these cases. Number 3, the parties acknowledge their duty to work together cooperatively through the discovery process. Don't you think it's so funny that they're now filing this after Brian Freeman just said, like, look, you haven't given us anything. You haven't done anything. You haven't been cooperative with us. So, like, here you are going to the judge to file a letter to compel, but yet you haven't even come to us yet. So now they're filing this stipulation for cooperation from all parties. Oh, wowzers. Okay. So the parties acknowledge that their duty to work together cooperatively throughout the discovery process, consistent with their obligations under applicable federal rules of civil procedure and the court's rules and guidelines. The parties will first attempt to resolve disputes regarding the issues set forth herein before filing a motion with the court or otherwise seeking relief. If a producing party cannot comply with any aspect of this stipulation, such parties shall inform the requesting party in writing before the time of production as to why compliance with the stipulation is not possible. Number 4, nothing in this stipulation shall be deemed to waive or limit any party's right to object to the production of certain documents. And then they go into the definition of what all of the documents are. The search protocol. The parties will meet and confer within a reasonable period of time after entry of this stipulation in an effort to conduct discovery in the most efficient and effective manner. Specifically, the parties will attempt in good faith to come to an agreement on search and culling methods used to identify responsive information. Collecting of documents and categories of documents and communications that are likely to contain information relevant to the above captioned action and responsive to a party's document request, and that they are regularly maintained in a known location or in a location that is knowable upon reasonable inquiry of those who with knowledge of a party's document management, shall be collected without the use of search terms or other agreed upon advanced search methodology. Analytical, The aforementioned shall not prevent a party from using date filters beginning in December 1st of 2022 to collect email accounts, Google Workspace, file shares, and cloud documents, where doing so will not negatively impact the collection of potentially responsive information. The parties agree to meet and confer regarding any other source in advance of collection. For the avoidance of doubt, date restrictions shall not be used for messaging communications. Search methodology, then they go into how they're supposed to search for stuff. And yeah, pretty much, you know, all of the stuff that they're looking to get and how they're going to do it. Now, this was all filed from Ryan Reynolds and Blake Lively literally after Brian Friedman said that y'all are not cooperating whatsoever. Basically, with this stipulation, what it just means is how they're all going to work together. Now, this is only between Blake Lively, Ryan Reynolds, Vision PR, Leslie Stone, Stephanie Jones, Jonesworks, Wayfarer Studios, and its leadership, and Jennifer Abel. The people who did not agree or join this agreement, I should say, is the New York Times, Jed Wallace, and Street Relations, Jed Wallace's company. It So basically, they're just saying how they're going to work cooperatively together and in good faith, how they're going to search for emails, text message, documents, and all of the technological procedures they're going to do, and to use date filter starting December 1st of 2022, which I think is so nuts that Blake and Ryan even want to go back to December 1st when Lively was first cast. Like, they're really trying to paint a picture that Wayfarer's parties and Justin Baldoni and Jamie Heath from the beginning had this huge master plan to just bring Blake on so that they could continually sexually harass her and then start a smear campaign to make it go away. Like, oh my gosh. But this is good because that means also that the Wayfarer parties can also search for stuff starting December 1st of 2022. And it just goes on about the strict rules and the protective, private, and privileged information. I guess that is a huge thing for Blake and Ryan. And to allow clawbacks, meaning if a party accidentally turns over privileged info, they can ask for it back without waiving legal protections. So that's what they filed, and everyone did agree to it. The next day, all parties agreed to this stipulation of how they're going to collect data. And yeah, it's kind of good. It's strange that they filed this now, and especially after they filed motions to compel, and the Wayfarer people were like, well, they didn't even ask us for this kind of stuff. It's kind of weird. Next on the court docket is the letter reply in response to the motion. It is addressed to the judge, and this is a letter motion for discovery addressed to Judge Lehman, and this is from Jones Works, and it's filed in association with these cases. So let's read what Miss Stephanie motherfucking Jones has to say about this now. And already, just knowing Stephanie Jones and how her lawyers speak, and like snarkiness and complete avoidance and playing the blame game, which I suppose that's what you gotta do because like you are being dragged, girl, because illegally and now morally you are in the wrong. I mean, everyone knows that subpoena, you could have fought, you could have argued, you didn't have to give them the communications. In the very least, you could have let your ex-clients or clients know. I mean, it's just so gross. I think there is going to be a stance of legality, and then there's also a stance of morality. I try to always base my own opinions and my judgments on morality because there are laws out there that I just think are wacko-nacko. Like, wacko-nacko? I don't even know if that made sense, but are wacko. So I just try to always base my opinions and judgment on the morality side of things. But I think now, legally as well, now that they've brought in the crime fraud as well as the subpoena and fake lawsuit, a lot of things are going to go down legally as well. So this was the letter that Stephanie motherfucking Jones was able to file to the court, and this is what it has to say. Dear Judge Lyman, in their opposition to Jones Works' motion to prevent the Wayfarer parties from using a third-party subpoena to Edgeworth Security Services, LLC, to invade Jones Works' attorney-client privilege and work product, the Wayfarer parties engaged in litigation by ambush. They assert an outlandish theory that they never raised during multiple conferrals and assets facts without evidentiary basis. The court should reject their baseless argument and grant Jones Works' motion. As an initial matter, the Wayfarer parties fail to contest that the documents they seek from Edgeworth's are Jones Works' privileged documents. Indeed, by invoking the crime fraud exception, the Wayfarer parties have conceded the privilege. Because, as detailed below, the Wayfarer parties' invocation of the crime fraud exception fails to meet any of the requirements for the exception, and they have not otherwise challenged Jones Works' privilege, the court should uphold that privilege. The Wayfarer parties have fallen far short of asserting a proper, let alone viable, invocation of the crime fraud exception. A party seeking to invoke the crime fraud exception must demonstrate that there is probable cause, that the client communication or attorney work product is questioned was itself in furtherance of the crime or fraud, and 2, To believe that the particular communications with counsel or attorney work product was intended in some way to facilitate or to conceal the criminal activity. Yeah, I think that's the whole point of what they're trying to get to, is that you had Edgeworth Services walk Jennifer Abel into a boardroom. You scanned her entire laptop multiple times. Allegedly, Jennifer Abel says found nothing. Stephanie Jones is saying that she found a whole bunch of files that Jennifer Abel was stealing. Then you took her phone with promises of only taking it so that you could take the company phone back and still give Jennifer Abel her number, which we now know you didn't. That was not your intention. Edgeworth Services was there the entire time. So did they facilitate you committing crimes? I think it's pretty, to me, it makes sense. To me, it just makes sense. But maybe Stephanie Jones, she's not seeing that, right? She's still on the stance that she didn't do anything wrong. The showing that the exception applies must be made as to each communication. The Wayfair parties have the burden to submit evidence establishing probable cause that the crime fraud exception applies. So now she's saying for every single communication that they want from Edgeworth, they need to say why, versus just saying all communications between Edgeworth and Jones Works. And this is so rich considering Blake Lively first and is still trying to get every communication from every single employee in Wayfair since 2022, even though some of the employees only started there summer of 2024. All of these parties feel like they have all of these different rules for themselves, and it's just, to me, it's it's bananas. It's a telenovela in itself. It's honestly crazy, and I feel like we're only on season 3, The Wayfair parties have the burden to submit evidence establishing probable cause that the crime fraud exception applies. Even before the court can engage in-camera review of the documents at issue, the Wayfair parties must present evidence sufficient to support reasonable belief that in-camera review may yield evidence that establishes the crime fraud exception's applicability. And they must provide the court with sufficient facts supported by evidence to specify the factual basis for the crime or fraud that the documents or communications are deemed to have furthered. In regards to Richard Rowe, Inc., the Wayfair party's opposition fails on all fronts. First, I love she always does that in all of her things. It fails on all fronts. And then she'll go into, first, the Wayfair parties fail to even attempt to connect any of their arguments to any particular privileged document or documents. They do not even try to explain, for example, how a category of documents from May 2024 that relate to defamation against Jones Works 3 months before Abel's termination could have been intended to facilitate an undefined purported scheme related to post-termination conduct and events. The crime fraud exception only applies where there is probable cause to believe that the particular communication was intended in some way to facilitate or to conceal the criminal activity. The government must provide particularized evidence that each challenged communication was made in furtherance of the crime fraud. Second, the Wayfair parties present no evidence of their outrageous allegations against Jones Works. They present no evidence of their allegations that Jennifer Abel was falsely imprisoned by Edgeworth security personnel. They present no evidence of their allegations that Abel was coerced by Jones Works chief of staff and lawyer to return the phone Jones Works provided to her for her employment. They present no evidence that Jones Works assessed everything from her personal iCloud and email accounts. And they present no evidence of any of the suspicious criminal hacking allegations they level against Jones Works. 2. Instead, the only documents they cite at all for their allegations in Abel's own amended countercomplaint which is equally substantiated, unverified, and unsupported, but a complaint is not evidence and cannot support the Wayfarer party's attempt to invoke Jones Works privileges. The allegations in the complaint cannot suffice to establish probable cause to believe that a fraud was perpetrated. Otherwise, through the mere allegations of fraud in a complaint, a party could use the crime-fraud exception to wholly swallow the attorney-client privilege. Indeed, Jones Works has moved to dismiss Abels's amended counterclaims because the allegations are not only false, but would fail to support any legal theory she advances. The Wayfarer parties present no evidence of a crime, a fraud, or Jones Works' involvement in either. So their invocation of the crime-fraud exception fails. Well, maybe if y'all gave him the subpoena, maybe if y'all actually presented the lawsuit where you got the subpoena, let's get into it, you know? Still, come on, you're saying that you didn't? This wasn't all coordinated? I mean, you could only deny, I think, for so long before you actually have to, like, face the facts that, like, you're in trouble, girl. In fact, the Wayfarer parties present only 2 documents other than their own prior pleadings in perpetrated support of their argument: a complaint filed by a third party, not Edgeworth, in New York Supreme Court, and the notice of discontinuation of that litigation. Neither of these documents offer any factual or evidentiary support for any of the Wayfarer parties' wild claims. Even the Wayfarer party's effort to connect these 2 documents to Jones Works is supported by nothing more than wild speculation and yet more bald repetitions of things the Wayfarer parties previously alleged. What is more, despite the Wayfarer party's bombastic allegations of a sham action, those allegations, even take on their face, fall short of establishing any cogent theory of a crime or fraud involving Jones Works and Edgeworth that could support the exception. The cases the Wayfarer parties cite confirm this. For example, in Michael Greco Productions Inc. versus Alami Inc., the court found, based on evidence including altered contracts and the defendant's admission to having altered them, that the defendant presented an altered document to the court intentionally in order to defraud the court. The Wayfarer party's rhetoric aside, their bald allegation that Jones Works colluded with Lively to issue a lawful subpoena in a case that Lively purportedly did not intend to fully litigate falls well short of a fraud, corruption, the administration of justice that should sustain the exception. No, girl, I think for sure what you guys did was fraud. Like, Blake Lively filed a fake lawsuit with an inactive company to name John Doe's. So you're not even saying that you don't even know where it's coming from, just John Doe's 1 through 10, but knew to give it to Stephanie motherfucking Jones and knew to only get Jennifer Abel's communications. Make it make sense, you know? The Wayfarers party's lack of evidence is unsurprising, as the facts they assert are false. Jones Works did not imprison Abel. It terminated her employment in a conference room. It did not coerce her. It provided her documents that she reviewed and signed. It did not threaten her. It requested that she return the iPhone that belonged to it, and she did. It did not hack her iCloud account or email accounts or even access those accounts or any personal information. It forensically extracted data from the storage of an iPhone it provided to its employee to use during her employment. If the Wayfarer parties had evidence supporting any of their inflammatory assertions, they would have presented it to this court. That they did not both confirm the non-existence of evidence and defeats their opposition. The timing of this opposition coming just 2 hours after Jones Works' motion, its assertion of an argument not mentioned in over a month of conferrals, and reference to a since-abandoned claim all demonstrates that the Wayfarers' response was a pre-baked, media-targeted ambush, not a reasoned response to resolving a legal dispute. These tactics should not be indulged, and because the opposition fails even the most basic requirements of invoking the crime fraud exception, the court should reject it and grant Jonesworks' motion respectfully submitted. Ew! First of all, why would they... Come on! No one is picking up on these stories, Stephanie Jones. You have Taylor Swift being dangled in front of us. Ryan Reynolds is on every single talk show. You have Blake Lively filing motions saying that Wayfair haven't cooperated. They haven't proved any documents. Like, nobody is, like, this was definitely not for clickbait. And I think it's so hilarious that the opposing team of the Wayfair, and this includes Blake Lively, Ryan Reynolds, Leslie Sloan, now Stephanie motherfucking Jones, that every time Brian Freeman or the Wayfair parties choose to do something or file something or subpoena someone or do something, their only response is like, yo, they're doing it for the media. They're doing it for media headlines, you know? Who's really doing it for media headlines? Because ever since Taylor Swift and ever since Ryan Reynolds has been flaunting himself all over cameras, that's all anyone's talking about. So I don't know, to still take the position that you didn't do anything wrong and you only, like, you know, you only complied to a legal subpoena, eventually you're going to have to come up with a different defense. And I think those motions are coming where the judge is going to be like, okay, let me see this lawsuit. Okay, let me see this sham subpoena. Okay. And yeah, I don't know. What do you guys think about Stephanie Jones's responses here? I really think that she's going to have to answer for a lot of things, but of course they're going to fight until they can fight. But Stephanie Jones is the one fighting the hardest right now. After that letter that was filed to the judge, Stephanie Jones also filed a memorandum of law in support to dismiss the amended third-party complaint seeking identification, and this was filed from Jonesworks in relation to a motion filed from Jennifer Abel. Stephanie Jones is really not trying to take any part in this. She's like, Jennifer Abel acted rogue. She's a rogue employee. I had nothing to do with it. Therefore, Jennifer Abel broke the contract with Jonesworks. I'm not responsible. Get me out of this. So this is a third-party defendant, Jonesworks LLC, and it's their memorandum of law in support of its motion to dismiss Jennifer Abel's third-party complaint seeking identification. Out of all of them, this is probably the longest one. It's like 26 pages or something, so we're not going to go over all of it. I will give you Cole's notes, but it is nice to always read like the preliminary statements. So here from Jonesworks, desperate to avoid paying the piper for her actions, Jennifer Abel throws yet additional outrageous allegations at her former employer, Jonesworks, but her ever-increasing parade of inapplicable statutes and claims cannot change the reality. Abel went rogue. She ruthlessly pursued her own career advancements by leading an unsanctioned smear campaign and pinning it on her employer, Jonesworks, while contemporaneously with Melissa Nathan spearheading a Business Insider hit piece against her boss, Jones. What? She's saying that, oh my gosh, I gotta pull up the Business Insider. This is the first time I'm reading this one because it was so long I was like, I don't know if I'm interested in it, but what? This is the Business Insider piece, and this article is juicy, 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 juicy. It's all about Stephanie Jones and how she's a monster to employees. So what she's stating here is that Jennifer Abel and Melissa Nathan got together beforehand and started this piece on Stephanie motherfucking Jones. If y'all ever want me to go through this article, it tells you everything you need to know about this woman. But wow, what a statement to come out from Stephanie Jones, that she's now claiming Jennifer Abel and Melissa Nathan started this Business Insider article about her. Wow. I just think that is so wild and fascinating all at once. Oh my gosh, I never heard that from her before, she's blaming all of the bad PR and all of these articles that were coming out. I don't think I ever heard her pin that on anyone yet, and now she's saying it was Melissa Nathan and Jennifer Abel. Oh my gosh. What do you guys think about that? She literally, in her other thing, said that she hired Edgeworth to find out who's behind these PR and things coming out. So I don't know. This is so bizarre. Anyway, back to it. With Melissa Nathan spearheading a Business Insider hit piece against her boss, Jones, stealing confidential documents, poaching clients, and seeking to ruin Jones' decades-built reputation. Her duplicitous plan nearly succeeded until Jones Works caught Abel red-handed. Now Abel brazenly seeks indemnification from the employer she betrayed and sought to ruin. Her claims are as meritless as they are outlandish and should be dismissed. Abel's claim for identification fails under even minimal scrutiny because such relief is unavailable when she was acting in her own interests, which she actively hid from and were opposed to those of Jones Works. That was exactly what Abel was doing. Abel admits that starting as early as July 29, 2024, weeks before she left Jones Works, and continuing through August, the exact time she was engaging in the conduct for which she now seeks identification, she was communicating with co-conspirator Nathan about their scheme for Abel to leave Jones Works, poach his clients, and profit Jones Works' expense to answer. So they keep using the same messages because Jones Works put these same messages in her Jennifer Abel answer in the other lawsuit. So again, without context, it's very interesting because we now know that they are really good at just cherry picking text messages. But this one says, from Melissa Nathan to Jennifer Abel, I know, and once you are gone, we will be on all accounts together and make really good money and be happy. Then she says, let's just keep it steering that way, and you take this fucking client and never talk to her again, I swear to God. That was September of 2024. Well, yeah, of course, because Stephanie Jones was causing so much chaos at that time. She was going behind Wayfarer's back. She was going behind Sony's back. She was talking to Leslie Sloan and the media. She was making their lives hell. And this was already after. Oh, wait a second. This was on, it looks like, wait a second. Sorry, this wasn't in September. This was on August 9th. Just going back to the timeline here that we had, because I don't want to give any information. I thought for sure if it was September, yeah, you walked Jennifer Abel out on August 21st, but now it's showing that this text was from August 9th. But still, I just want to make sure that at this time through August 9th, there was already still online chatter escalating. Abel and Sloan, they did reach an agreement on August 8th, but then 9 minutes later, Sloan broke the agreement. And yeah, Jones on August 8th, there's emails and text messages between Stephanie Jones to Jamie Heath about not contacting the Daily Mail, and Jamie had told her to stop. So they found out that Stephanie Jones was contacting reporters against their will. So that to me just makes sense that they would text them like, hey, don't worry, girl. Like, once you're out of there, it's just going to be you and me. We're going to do so good. We're going to get money. Like, fuck this F this B, you know? I had to take that back, guys, because I really went in there. I said some curse words, which I don't know are appropriate here. Back to Stephanie Jones. Then she goes on to say, Abel admits that while employed at Jones Works and doing the period for which she seeks identification, she was boasting to Nathan about her overt hostility to Jones Works. So we'll just read those. Let's read the messages. So it says, we are going to war. I feel so alive. Ha 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 ha. I'm not sure if that all means what she's saying it means. But anyway, Abel admits that she intended to shake down Jones Works on her way out. There's a text from Jennifer Abel to Melissa Nathan saying, by the way, I'm having my offboarding this morning with our chief of staff, a joke, because Steph won't face me. And you should see the list I made of things to bring up. And then she wrote, holding them hostage. That just means that they're doing, if you worked at any professional place, there is an offboarding meeting. There is a meeting that you have to discuss what you liked, what you didn't like, all of this stuff. So I mean, it just seems like she did not like working there, and Stephanie Jones was a monster, and she was going to tell her exactly how she felt on the day. Abel admits that in parallel with the actions for which she now seeks identification, she and Nathan were encouraging Wayfair and Baldoni to breach their contract with JonesWorks so they could steal them as clients. Now, here are some more messages. Again, these messages, taken from Jennifer Abel's phone without Jennifer Abel knowing. So this message is from Melissa Nathan, Jennifer Abel again. Let's keep it steering that way, and you take this fucking client and never talk to her again. I swear to God. And then she wrote exactly, and then they wrote, and I'm just going to step out of line before I go to bed and tell you Jen is amazing. She's so loyal. She loves you so much, and you have to go with her. And he was like, oh my God, of course, I'm going to go with her. Don't kill me. Okay, bye. So Melissa Nathan, it seems like this is from Melissa Nathan talking to the Wayfair parties, but again, without context, you have no idea who they're talking about or what they're talking to, Ha ha ha, oh my God, love you. But that doesn't have anything to do, it seems like, with Jennifer Abel. That has to do with Melissa Nathan saying that she said that y'all should go with Jennifer Abel when she leaves. Abel admits that throughout this period, she facilitated and regularly communicated with a Business Insider reporter, including through at least 4 phone calls, one more than 27 minutes long, and numerous text messages with the reporter, and text messages coordinating the reporter's outreach to others to actively undermine Jones's reputation and JonesWorks' business through a hit piece about JonesWorks and Jones and JonesWorks. And then they have a text here saying, Stephanie, are you aware there is a kill story dropping this week on you, and you hadn't have blown us up, we would not been in such a bad place? What? So because it says that it's from Melissa Nathan to Jennifer Abel, but then it's saying to Stephanie, I don't know. So it's just saying, are you aware that there is a kill story dropping this week on you, and if you hadn't have blown us up, we would not have been in such a bad place? Abel admits that the reporter thanked her for her help with the story. Story's up. Thanks again for your help. Abel admits that she was working at, what she's saying, Abel admits, and then the text that she's showing to me doesn't show that, but maybe I'm the only one, but I don't know. It definitely doesn't look good for Abel if she was working with the Business Insider, but also Stephanie Jones is a monster, so you're going to get your company the way you're going to get your company. If you're working for a boss, ew, I could never imagine working for Stephanie Jones, honestly. Abel admits that she was working at JonesWorks supposedly in the interest of its then client Baldoni. She was simultaneously trashing him behind his back and crediting the very rumors she was working to suppress. So I guess these are the same ones that they always show, from Melissa Nathan to Jennifer Abel, just saying that he's so cringe, he's so gross. Blake was probably grossed out too, and saying, like, I can't stand him, he's so pompous, a men's retreat during release, is he crazy? And being off the grid for the summer because he's just so overworked. Like, calm down, you're not that important, and nobody gives an S how hard your life is. And then another one from Jennifer Abel to unknown source, saying he may fire us because even if we put together an amazing campaign, it's not going to change the fact that he's so unlikable and unrealistic as a leading man. There's no chemistry with him and Blake. You and I both know that she will be resistant to promote this movie, and and press will be reluctant to do anything with Justin without Blake being a part of it. So those are my thoughts. I mean, she was right. Blake was very reluctant to promote the movie without everything that she wanted. Abel also admits during the time Nathan was not safe from Abel's trash talk, labeling her as an expletive even when she worked with her to harm and steal from Jones and JonesWorks. I feel like all they're trying to do is like really show that Abel is bad, like turn the Wayfair parties against Abel. But we shall continue. We've already read those text messages in the other docket. And Abel admits that when JonesWorks finally discovered her self-serving thievery and duplicity and limited her access to its electronic systems, she boasted about evading the company's effort to stop her theft. Yes, pretty much. I have my way around that shit because I have like hundreds of different emails for each domain that I own, so she can suck it. Again, without any context, I mean, I don't know. I don't know what they're trying to get at, but it continues. Abel's claim that she is entitled to identification from the employer she was actively betraying is diabolically illogic. Abel's claim that she is entitled to identification from the employer that she was actively betraying is diabolically illogical, legally deficient, and must be dismissed. Abel also cannot plausibly plead that she was acting in the scope of her employment or as Jones Works' agent when she was actively refusing to follow Jones Works' instruction and hiding her activity from the CEO, and even now antithetically alleges that Jones was interfering in Abel's effort to conduct the very smear campaign at issue here. Abel proudly pleads that she advised Wayfarer to hire Nathan, knowing full well that Jones opposed this recommendation. Counterclaims that Abel objected to Jones's inserting herself into the mix of working on behalf of Wayfarer in early August 2024, and that Wayfarer instructed Jones to cease all activities on behalf of Wayfarer and Baldoni. She even has the audacity to claim that she was working in the scope of her employment at Jones Works in the same breath as attacking Jones Works' CEO, for refusing to be sidelined. But texts that Abel admits to sending and receiving confirm that she and Nathan did sideline Jones and Jones Works, including when those two co-conspirators ironically commiserated about the misogynistic nature of their vile campaign against Jones and Lively, and unbelievably attempted to blame Lively for their ruthless campaign. What? So now Jones is saying that there is a smear campaign against her. So not only did Jennifer Abel and Melissa Nathan help coordinate the smear campaign against Blake Lively, but boo-hoo, I'm a victim. They also did it to Stephanie Jones. These women are just out here just doing smear campaigns against other women. It's just so funny. Her stance in this is just like, oh my gosh. But there is some more text here from Jennifer Abel and Melissa Nathan. It says, it's actually sad because it shows you how people really want to hate on women. I know it is sad, but then don't be a see you next Tuesday. And I mean, yeah, man or woman, you can't get away with being a monster anymore. Abel's contribution claim also fails legally, factually, and logically. Not only does Abel fail to identify a single action by Jones Works that allegedly contributed to the harm Abel inflicted on Lively, she fails to even try to plead any of the required elements of this claim. This is not surprising, as the apparent core of Abel's ever-evolving claim is that Jones Works somehow concluded with Lively. Somehow concluded with Lively? What? But Jones Works could not possibly have contributed to the harm that Abel and her co-conspirators caused Lively by colluding with Lively. Abel's fantastical claims, ranging from collusion to contribution, are unified in one respect: they do not pass the smell test. Abel's assertion that Jones Works, whom she is suing in related litigation to this in this court, must now find her defense in litigation that seeks to call her to account for her misconduct is beyond the pale. Her claims fail as a matter of law and should be dismissed. Then they go into the background of how Abel joined Jones Works, which is already copy and pasted, I'm pretty sure, from her other motions in the actual Abel versus Jones Works case. Then it says Abel runs an unsanctioned shadow campaign to smear Lively and attack and steal from Jones Works. Shortly after joining Jones Works, Abel began working on the Baldoni and Wayfarer accounts, for which Jones Works entrusted Abel to be the point person. Third-party complaint: although Abel was the person with day-to-day responsibility for these relationships, Jones Works, primarily through Jones, supervised and directed her work until Abel went rogue. Then they just go on to explain how the summer kind of happened, how Abel wanted to get Melissa Nathan, Stephanie Jones didn't want to, We read all of this before. It is interesting that JonesWorks is taking the position that Jennifer Abel was going rogue and stealing information. It says here too, simultaneously, Abel was actively planning to leave JonesWorks and start her own business to compete with JonesWorks, using JonesWorks' proprietary information and strategies and with JonesWorks' clients. While still employed by and collecting a paycheck from JonesWorks, Abel set about pillaging the company for anything she could take on her way out the door. Despite still being a JonesWorks employee, Abel furtively filed articles of organizations for her new company, RWA Communications. Answer to Jones. She also stole JonesWorks' confidential documents and clients, both in express violation of her contract and her obligations as an employee. Abel further admits that she communicated regularly with a Business Insider reporter who was writing a kill story about Jones and JonesWorks while Abel was still employed by JonesWorks. She further arranged to remove from the story a letter of support for JonesWorks from Baldoni and coordinated others' negative participation in the article. On August 21st, 2024, JonesWorks terminated Abel after discovering Abel's theft of confidential JonesWorks documents. Wayfair soon followed Abel, purporting to terminate its contract with JonesWorks and hiring Abel's new company. JonesWorks only became aware of Abel's broader campaign of egregious misconduct, including the actions for which she now seeks identification, after discovering Abel's conduct through messages on her company-issued phone. There is a lot to go over in this one document, so maybe I will just do a whole video, a brief video tomorrow just on this one, but I do want to move on to the other motions. So I'm just going to break down the basic points for this one, and then if you'd like, we can read it from start to finish tomorrow. But what they're basically saying is Abel acted on her own for her own benefit, not JonesWorks. That she broke her employment contract. She wouldn't steal clients or documents. She would always act in the company's best interest, and that she'd follow New York law. Abel's campaign was secretive, rogue, and against their orders. So Jones is saying that she didn't know. And all of the things that she did undermined and went against Stephanie Jones. And the common sense says it's absurd. She trashed the company, stole from it, and now wants to cover her legal costs. That's crazy. That's coming from Stephanie Jones. So they're saying contractually and under the New York law, this should not work. This should be dismissed. Stephanie Jones is also saying Jennifer Abel betrayed us. She planned a smear campaign against Lively, stole our clients, trying to ruin our CEO's reputation, and now wants us to pay her legal bills. Legally and logically, that makes no sense. Throw her lawsuit out. We are almost there. Next, what happened is the joint stipulation that we read, the protocol for discovery of electronic information. That was signed and agreed upon by everyone that was involved. The next thing was a letter addressed to Judge Lehman. This is regarding the Wayfair Party subpoena to Venimal LLP, and this was filed by Blake Lively and Ryan Reynolds. There was a motion from Venimal, which is from Taylor Swift's law firm. They were subpoenaed for communications. This is a response from Blake Lively and Ryan Reynolds in order to squash that subpoena. So they're seconding what Taylor Swift's people already filed. I can't get into that motion yet. It's sealed, it's locked, it's not there. I don't know what's going on, but I've seen other people talk about it. And it's also big headlines. Taylor Swift's trying to squash the subpoena. So Blake Lively and Ryan Reynolds wanted to get in on that too and just say like, hey, brah, we feel the same way. Squash that subpoena. So here is that letter. What I found interesting is that there was this one submitted and then right after a correction one. So this is the original, not the corrected. I haven't even seen what the difference is, but maybe I'll put those two into a little chat GPT and see what the differences are or pull them side by side. But this was the original one filed on May 13th, 2025. This is from the Lively and Reynolds party. Okay. Dear Judge Lyman, pursuant to Rules 1C and 4C of the court's individual rules and practices, Blake Lively and Ryan Reynolds, the Lively Reynolds party, respectfully submit this letter to advise the court of a dispute concerning the Wayfarer party's third-party subpoena to Venable LLP. In the above captioned cases, the actions. On April 28, 2025, counsel for the Wayfarer party served a notice of intent to subpoena Venable, a law firm that does not represent any party to the actions and, as of the date of service, did not represent any third party served with discovery in either of the actions. The subpoena seeks all communications between Venable and the Lively Reynolds parties concerning the actions, all documents concerning such communications, and all communications between specific attorneys concerning Lively. On May 12, 2025, Venable filed a motion to squash the subpoena in the District of Columbia. See Venable LLP versus Wayfarer Studios LLC. In the interest of judicial economy and efficiency, the Lively Reynolds parties joined Venable's motion in full and filed a motion to intervene for the limited purpose of moving to squash the subpoena. The subpoena seeks the Lively Reynolds party's attorney communications, including those of Michael Gottlieb, with no explanation on how they could be relevant to any party's claim or defenses in this action. In light of this, the Lively Reynolds parties have requested that the subpoena be squashed. I'm going to see if I can quickly find this motion to squash. Found it. That was easy. Just looked it up here. Wowzers. Okay. I found it. It's long. We will go over this. How about tomorrow we go over the Venable motion to squash, as well as Stephanie Jones's 26-page thing, because those two are very long. But yes, they did file this motion. So this is a whole new other lawsuit. It is not even tied into the Lively and Reynolds and all of those people. This is just Venable LLP versus Wayfarer Studios LLC. So they are really fighting to not have to turn over records here, and we will go over that tomorrow. If anyone wants to see the corrected letter, this is it right here. It looks the same. I'm sure there is just a few things changed, but this is the corrected letter they filed. It's pretty much the exact same thing. And yes, late night last night, Brian Freeman did respond in Brian Freeman fashion. So let's get into it because it gets juicy. This was filed by Brian J. Friedman on May 13th, 2025. Now, this is exactly what it says. This is a letter response in opposition to motion. This is addressed to the judge, and this is from the Wayfarer's letter of motion to squash the subpoena. Brian Freeman answered at late night last night. Okay, at all hours this man is working, but late night he says this. Dear Judge Lyman, we write in opposition to Blake Lively's motion to compel certain non-party individuals, collectively the non-parties, to comply with subpoenas, the subpoenas and the motion. The subpoenas do not call for compliance within this district, but rather in California and Georgia. Federal Rule of Civil Procedure 37A2 provides a motion for an order to a non-party must be made in the court where the discovery is or will be taken. The party that served a subpoena may move the court for the district where compliance is required for an order compelling production. Therefore, the non-parties respectfully note that this court lacks jurisdiction to compel their compliance with the subpoenas. Denying motion to quash subpoena and cross motion to compel compliance with the same because compliance was required in the Northern District of New York. Nonetheless, as repeatedly conveyed to Lively's counsel, The non-parties assure the court that they are diligently searching for non-privileged relevant documents responsive to the subpoenas and within their possession, custody, or control, and reproduce them as soon as reasonably practicable. With respect to non-privileged relevant documents responsive to the subpoenas that reside on Wayfair Studios LLC, Wayfair servers or databases, such as emails to or from a Wayfair email account used by one of the non-parties, Wayfair has already assured Lively that any such documents will be produced by Wayfair. Notably, neither Lively nor her husband, consolidated defendant Ryan Reynolds, has produced a single document. Moreover, both Lively and Reynolds have categorically refused to provide any information regarding the process by which they allegedly searched for documents responsive to the Wayfair party's request. All that is known, though not disclosed by Lively, is that she improperly obtained defendant Jennifer Abel's documents from Jones Works LLC pursuant to a so-called subpoena issued in a sham lawsuit filed without notice to any of the Wayfair parties, as detailed in our letter dated May 9th, 2025. We respectfully request that the court denies Lively's motion. So that's why basically Brian Freeman's like, you can't ask me to squash a subpoena for something that's not even in this state. So that's why it's now Venable versus Wayfair Studios, and that is in the District of Columbia, not in New York. So they're not even on the right track. And basically he's saying, girl, you and your husband better take care of your own house before worrying about anyone else's, because listen up, your house isn't in order, sweetheart. You haven't replied to one single thing yet. Unbelievable. And truly, this last paragraph is honestly chef's kiss, okay? Because I could read this all day. Notably, neither Lively nor her husband, consolidated defendant Ryan Reynolds, has produced a single document. Moreover, both Lively and Reynolds have categorically refused to provide any information regarding the process by which they allegedly searched for documents responsive to the Wayfair party's request. All that is known, though not disclosed by Lively, is that she improperly obtained defendant Jennifer Abel's documents from Jones Works LLC pursuant to a so-called subpoena issued in a sham lawsuit filed without notice to any of the Wayfair parties, as detailed in our letter dated May 9th, 2025. There's more to come, y'all. There is more coming out that Brian Freeman, I think he is just getting started. The more they toy with him, you can't even make this up. As I was making this video, that was the last motion. 2 more have been submitted, and it's from the judge. We're going to go over it because this just in, you know what I mean? This just in. And the judge has granted part of Lively's motion and also denied part of her motion. What he has denied is documents from Abel and Nathan. He's denied from Baldoni, Heath, and Sorit certain documents. And the requests for tax returns have been denied. Okay, what he has granted is a few other things, documents from other things from the agency tag he's approved, and also from some stuff from the Wayfair Studios. So we're going to go over them right now. We're going to go over that right now. Let's go. I just put on the screen here exactly what we're working with if you wanted to see it. So May 14th, 2025, a memorandum in order granting in part and denying in part. Granting in part and denying in part, motion to compel in cases. So we are going to look into that. And then filed a letter addressed to the judge. And this is again from Brian Freeman. And it's regarding the Venable subpoenas. So we'll see what else he has to say about that real quick. You will be happy to know that this is only 5 pages, so really 4, because this is the title page here. This is a memorandum and order. Here it goes. Blake Lively, plaintiff in Lively versus Wayfarer Studios, LLC, moves to compel defendants Wayfarer Studios, LLC, Wayfarer, Justin Baldoni, Jamie Heath, Steve Soritz, It Ends With Us, Melissa Nathan, the agency group known as TAG. So that's Melissa Nathan and Jennifer A. That's Melissa Nathan's thing is TAG and I thought that was Jed Wallace and Jennifer Abel, and collectively the Wayfarer parties. To produce documents responsive to requests for production, RFPs 46 and 47 as to Abel and Nathan, 49 and 50 as to TAG, 58 and 59 as to Baldoni, Heath, and Storitz, and 73 to 74 as to Wayfarer and It Ends With Us, collectively the financial RFPs. Docket numbers 202 and 203, the financial RFPs are similar for each of the Wayfarer parties. For Abel, Nathan, Baldoni, Heath, and Soritz, they call for documents sufficient to show your net worth, including financial statements, assets, liabilities, and tax returns, and all documents concerning your liquidation of assets in 2024 and 25. For any reason related to the film or the actions, including but not limited to the sale of shares in any publicly traded company. So then it goes on to all of the docket numbers from Abel, Nathan, Baldoni, Heath, and Soritz. For TAG, Wayfarer, and It Ends With Us, they call for your tax return, financial statements, and year-end balance statements, and for the period of June 1st, 2020 through the present, and all documents sufficient to show your gross income, net income, and expenditures. Federal Rule of Civil Procedure 26B provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. Relevancy under Rule 26 is to be construed broadly to encompass any matter that bears on or that reasonably could lead to other matters that could bear on any issue that is or may be in the case. Holding that the broad scope of discovery delimited by the Federal Rules of Civil Procedure is designed to achieve disclosure of all the evidence relevant to the merits of a controversy. So he's just quoting from some laws, noting that the information sought not be admissible at trial to be discoverable. The Wayfarer parties are seeking substantial economic damages, in this case from Lively's alleged tortious conduct. The Lively parties have cost the Wayfarer parties their file, their reputation, their future prospects, even their talent agency, alleging that as a result of the tortious conduct of the Lively parties, the Wayfarer parties have suffered loss of income and interference with future income, that Baldoni, Heath, Nathan, Abel, and Soritz sustained harm, including to their business and professions. At 222, prayer for relief seeking a money judgment representing compensatory damages, including consequential damages, lost wages, earnings, and others sums of money together with interest on those amounts in an amount to be proven at trial, but in no relevant less than $400 million. Documents sufficient to show the net worth of each of the Wayfarer parties, including financial statements, assets, and liabilities, are for the corporate entities. Financial statements, year-end balance statements, and documents sufficient to show gross income, net income, and expenditures are relevant and should be produced. Financial statements are relevant to any claim for lost profits. However, Lively has not shown an entitlement to the tax returns of the Wayfarer parties due to the private nature of the sensitive information contained herein, and in part from the public interest in encouraging the filing by taxpayers of a complete and accurate returns. Courts have long been reluctant to order discovery of tax returns. A party seeking to compel production of tax returns in civil cases must meet a two-part showing. The tax returns must be relevant to the subject matter of the action, and two, a compelling need must exist because the information is not readily obtainable from a less intrusive source. Then he cites all of the laws about that. Routine discovery of tax returns is not the rule, but rather the exception. Although the returns are relevant to the subject matter of the action, Lively has not shown that the information she seeks will not be contained within the other documents she has requested and that the court has ordered be produced. Lively also has not shown that documents concerning the liquidation of assets by Abel, Nathan, Baldoni, Heath, and Sorowitz are relevant to the claim for damages. Holding that information regarding a party's ability to satisfy a judgment ordinarily is not discoverable prior to the entry of judgments. Lively's motion to compel is accordingly granted in part and denied in part. The Wayfarer parties shall produce the documents responsive to RFP 46 directed to Abel and Nathan, RFP 58 directed to Baldoni, Heath, and Sorowitz, RFPs 49 and 50 directed to TAG, and RFPs 73 and 74 directed to Wayfarer, and it ends with us, except for tax returns, by no later than May 28, 2025. The request for tax returns and the motion to compel documents responsive to RFP 47 to Abel and Nathan and RFP 59 to Baldoni, Heath, and Sorowitz is denied without prejudice. The court awards costs to neither side. The clerk of court is respectively directed to close the motion in docket numbers 202 and 203. This is very interesting considering we were just reading that. And I think last week we went over the motions to compel them to do it. So some of it approved, some of it denied. Very interesting. This just came in today. And the next thing is we have another letter from Brian Freeman. This is Brian J. Freeman here that has sent this in. This is on May 14th. It's just arrived. And let's see what it is. It's only 2 pages. We'll get right into it. We write in response to the letter filed by Plaintiff Consolidated Defendant Blake Lively, Miss Lively, and Consolidated Defendant Ryan Reynolds, together the Lively defendants, regarding their requested intervention in an action in the United States District Court for the District of Columbia, seeking to quash the Wayfarer Party subpoena, the subpoena to Venable LLP. So they really then went to the District of Columbia. The Wayfarer parties anticipate that Venable's motion to squash will be mooted in short order, as their counsel and Venable are conferring in good faith. So, wait a second. Venable is actually conferring and working alongside them in good faith, it says, but then Blake Lively and Ryan Reynolds are trying to squash the subpoena. That's what they're alleging. However, the Lively defendants insistent that the subpoena seeks irrelevant information is wrong. Look at this. Look how this is wrong. Bold letters. Wow. The subpoena aims to obtain discovery relating to witness tampering and evidence spoliation. The subpoena aims to obtain discovery relating to witness tampering and evidence spoliation. Specifically, the Wayfarer Party's counsel are informed and believed, based on information from a source who is highly likely to have reliable information, that 1. Miss Lively requested that Taylor Swift delete their text messages. 2. Michael Gottlieb of Wilkie Farr, counsel for the Lively defendants, contacted a Venable attorney who represents Miss Swift and demanded that Miss Swift release a statement of support for Miss Lively, intimidating that if Miss Swift refused to do so, private text messages of a personal nature in Miss Lively's possession would be released. The Wayfarer Party's counsel are further informed and believe that a representative of Miss Swift addressed these inappropriate and apparently extortionate threats in at least one written communication transmitted to Mr. Gottlieb. It is those communications that the Wayfarer Party seek to obtain by way of subpoena, as they would evidence an attempt to intimidate and coerce a percipient witness in this litigation. As stated, the Wayfarer Party's counsel are in active discussion with Venable to determine how to proceed. Should those discussions prove unfruitful, the Wayfarer parties will either oppose the motion to squash or withdraw the current subpoena in favor of an amended subpoena seeking only the communications in question. Oh my gosh. Blake Lively and Ryan Reynolds were threatening Taylor Swift's people to put out a statement or they were going to leak information. Oh, no way. Oh my gosh. This just in, May 14th, Brian Freeman said it. We have answers. We have answers. I don't even know what to say. I'm so stunned right now, guys. And like, next, I was just going to go over some of your comments, and some of your comments are about the Taylor Swift, and now I'm like, we have answers. This is, as I was doing this video, what was I saying at the beginning of this video? Things are about to go down. Brian Freeman knows some stuff. OMG, that was a wild ride. And now, yes, let's just get to a few comments because this video is going to be about 2 hours long or something, you know? So let's just go. Here are a few comments. I was watching another channel and the lady is an intuitive reader and she said something interesting. We've been looking at interviews with BL that we haven't looked at the ones JB has given, and she specifically showed the one where he talks about looking through tons and tons of videos of social media accounts to find young Isabel, and then they brought up how Blake Lively and Taylor Swift found her, and then he had to stop and think and then changed his response. I've seen that. Honestly, I saw that when it was happening, and I felt so bad for Justin Baldoni because, like, they were stealing the sunshine from him, you know? They were stealing the spotlight yet again. That part is very bad. And of course he ends it with, that's a true story. And you know, if you have to end it with like, that's the truth, it's probably not the truth. This comment says, at BattleDog1, Taylor has some pretty damn smart people on her team. And if they think she should dump her best friend, then this case must look pretty bad. I imagine if Blake had a better case, she'd stand by her side to protect women. I agree. And now we kind of get a little taste of what is actually going on between these two. BattleDog1 says, again, I find it pretty gross the way these lawyers twist the law to whatever suits them. One group is saying a sham John Doe subpoena is normal, and now Taylor's lawyer is talking about giving the person a heads up to react. Absolutely. Again, it's like Stephanie Jones was the one saying, like, I didn't know anything that they were even going to bring crime fraud. Like, they didn't tell me. Come on. You should have known immediately. And I think she knew that this was going to be brought up when she started bringing on all these extra lawyers, you know? Miss Fox's plan says, isn't it hilarious how Jones is seeking to have this protection but never afforded this to her clients' information and just freely handed it to Blake? So funny, doubling down or what? Yes, I absolutely agree when it comes to the Stephanie Jones thing. Like, OMG, girl, like, come on, you know? At Blonde Bestie 1999, thank you for your coverage and making these documents so funny. I don't understand how Blake and Ryan aren't sweating. I worry the judge will let the sham lawsuit slide. I don't know how they can justify it though. Yeah, I don't know. It's going to be very interesting. I mean, this is the first time that now the judge has it in front of him. Before that, it was just like on the internet. It wasn't, but now it's actually officially been introduced. And that's why I think it's so weird that Ryan and Blake are just going around like everything is so cool when like, what? And then Mechanic Tone. Oh gosh, I'm so sorry. But it says, as Blake showed in her amended complaint, she was texting unnamed actress and Liz Plank about the tongue and eyes and HR madness. So why not Taylor? Exactly what I've been saying, girl. Why not Taylor? If this shit was happening, if this stuff was happening, you would be texting your bestie 100%. Okay, that is the episode. I really did not realize that we were going to get so deep into it. Oh my gosh, I cannot believe this new letter that Brian Freeman, I'm just like, I'm really shocked right now. It's amazing. I think that we are going to find out a lot more. Man, are Ryan Reynolds and Blake Lively not looking good. They are not looking good. Said it from the beginning. These two, I think, in my opinion, are evil. They're monsters. They've been doing dark stuff for so long and no one actually ever shined a spotlight on it, but now is the time. And we're gonna see what Tay Swizzy has to say about this letter, because if there is proof that Blake Lively's team was threatening Taylor Swift's team, I wouldn't say Blake Lively and Ryan Reynolds are bigger than Taylor Swift, okay? And that just shows why she hasn't said anything or is supporting her friend. I don't know. This is just so crazy. But if Blake Lively was trying to intimidate Taylor Swift, my gosh, that is wild. Wild. Witness tampering. Get her to delete text messages. Whew. But then again, does that dissolve Taylor Swift of any and all involvement with the takeover of the film and everything else? I don't know. I don't know. What do you guys think? You need to tell me. Drop your comments. With that being said, I didn't realize it was going to take almost 2 hours, but I'm so happy you're here. Yeah, I don't know. I'm just having, I don't know what to think about that last thing we just read. That's it. I'm going to have to like stew on it until tomorrow. Now, let's leave on a little bit of a good note. Anyone watch Handmaid's Tale last night? Woo! I don't want to give any spoilers, but on Friday I'm going to talk about it. So you have 2 days to catch up, okay? Because I have things to say. But we're going to end with a little listen, bitch, a motivational card. Let's see what we have. Your best is more than enough, I promise. Your best is more than enough. I mean, you can only really give your best, right? And that has to be more than enough. You showing up, you getting it done, you just trying and doing the best that you can do with what you know and what you have right now is good enough. Because every step that you take in the right direction and you only having the tools and what you have right now and what you know right now, that has to be enough. My phone is ringing once again. Okay, weirdly interrupted. No, that's fine. Honestly, your best is enough. Who you are right now, the tools that you have right now, the things that you know right now, everything is available to you. And that has to be enough, at least to get started until you know better, do better. Do you know what I mean? I swear, just who you are right now, knowing that you are enough and you are worthy and you are powerful because you are born that way, can change everything and literally transform your entire world. But it starts on the inside before it ever starts on the outside. So thank you so much for being here. Drop all your comments. I'm going to do a little short video right now on this so that we all get caught up real quick. And yeah, this video will be out soon as it's edited and blah, 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 blah. So thank you so much for being here. I hope you have the best hump day, a little bit more enjoyable than mine will be. But yeah, have fun. Go Leafs go tonight. Game 4. And thank you so much for being here. I love you. Thank you. I'll talk to you soon. Bye.